Hello and welcome to the next class on setting up of business, industrial and labor laws. In today's session, we are going to focus on part B of the subject, that is labor laws. And the chapter that we are going to discuss in today's session is the Sexual Harassment of a Woman at Workplace Prevention, Prohibition, Redressal Act of 2013. So by the name itself, you can make out that this particular enactment is for providing protection to women at workplace, to ensure that they have a safe working environment, that women, when they step outside their house for work, they are provided safety, they are provided protection. Why was there a requirement of bringing into existence this particular act? Earlier days, women never stepped out. They did not even have education. They were illiterate. But once the society started developing, education was provided to girl children. Opportunities came up that once they are educated, they can also take up employment. They can also take up jobs and go into the actual world and work. That is when women started stepping out for work, it was realized that there is no protection for them at workplace. A lot of wrongful activities or wrongful incidents were reported or were brought into existence that were not being discussed also. They were not even being reported. They were not even being brought into the knowledge of the employer as such, or anybody for that matter. That is when we realize that it is very important for us to have a specific law for providing protection to women at workplace, and that is why this particular act has been brought into force. But before going into understanding the regulatory aspect and legal provisions of this particular enactment, let us briefly see a historical background of how and what led to the bringing into force of this particular enactment. So it happened, like I told you, there were a lot of wrongful activities taking place against the women at workplace, but nobody was talking about it. Though everybody in the society knew that this particular issue is prevalent, it was not being addressed as such. Nobody took up the topic as discussion for bringing into impact a regulatory provision for providing protection to them as such, until one incident took place that was a heinous crime against one woman merely because of her work that she is doing. And this particular case commonly is called as the Vishaka case. The actual name of the case is Vishaka versus State of Rajasthan. This particular state case started in the year 1992. What happened in this particular case? There was this one woman, Bhanwari Devi. She was working with a NGO which was working for the rural development, and is based in Rajasthan. One of the topics or agendas that NGO was working towards was stopping child marriages, curbing child marriages which were prevalent predominantly in the state of Rajasthan. And that woman was associated with that particular project. So she was conducting a lot of sessions with the villagers about telling why child marriages are wrong and why child marriages should not take place, what are the advantages and disadvantages, as in why we should stop child marriage. One day she received a call saying that a girl child of less than a year's age, merely an infant close to 10 to 11 months old, is being married. A child marriage is taking place of a girl which is less than 1 year of age. And that is when she, in her professional capacity, went to that particular place to stop the child marriage. She wanted to stop that one small baby from being married off. And that started the entire scenario of revenge, how the family members of that particular girl child, which was influential at that point in time, tried to threaten this woman saying that you stop not dealing with this issue, don't interfere with the matter. This is a culture that is being practiced for ages together, and now you cannot question the same. You're going against the cultural historical background of our tradition, of our culture. And the woman was very strong. She was very passionate. She did not take about those threats very seriously. She started getting threats not only against her life but also for her family members and her children. But one fine day, she was brutally gang raped by the villagers, and the entire scenario of discussion came into being on the happening of this particular event, that particular woman did not have a personal revenge or any bad relationship with anybody in her personal capacity. This particular incident she had to suffer merely because of the kind of work she was doing. She had to undergo that particular incident because of her professional capacity. She was associated with the NGO, that is why she is conducting those events, that is why she is going to the various places and stopping child marriages from being taken place. So she has suffered that incident in her professional capacity. There is nothing to do with her personal life. So that is when the topic about providing protection to women at workplace was brought into force, and a lot of the working women in the countries, women rights activists and lawyers together came up and filed a public interest litigation before the Supreme Court of India under the Constitution, Article 32, in the name of the Vishaka, seeking protection for women at workplace. And the Supreme Court took up the petition, and for the first time it has acknowledged that there is a lack of legislation, there is a lack of law in the country for providing protection to women at workplace, and they indeed accepted that the workplace sexual harassment is a violation of basic human rights of the women who are working. So this laid the foundation, this public interest litigation that was filed on the happening of this particular incident against the women at workplace, which was a NGO. This particular case, this particular public interest litigation led to the passing of this particular enactment. So once the public interest litigation was filed before the Supreme Court, the outcome of that particular public interest litigation is the Supreme Court of India came up with a guideline which was called as the Vishaka guidelines. Very, very important. They said that we are going to create certain guidelines. Every employer is required to follow these guidelines for providing protection to women at workplace till a particular specific law is not being passed by the parliament. Because if today we know that there is a lack of law, we wait for the parliament to draft a law, to get it passed, to get it published in the official gazette, and then bringing it to force, it definitely is time consuming, and we cannot let this particular subject matter not being addressed at all for such a long duration of time. So today we are going to give you the Vishaka guidelines. This particular guidelines briefly gives down about how we are going to deal about the cases of sexual harassment of women at workplace, and they also directed the parliament, the center, that is the union, that is the central government, to enact appropriate law for providing protection to women at workplace against sexual harassment. So they have dealt about the situation in two ways. Today there is no law. We are going to give you the brief guidelines. You follow that, and we are going to tell the parliament you have to pass a specific law. Till the parliament does not bring into force a particular enactment, Vishaka guidelines itself is the law. You have to follow that. You have to abide by that. So this laid the foundation of bringing into existence a legal provisions of law for providing protection to women at workplace against sexual harassment. Now, what are the Vishaka guidelines? Vishaka guidelines, that is the judgment that was given by the Supreme Court. It initiated a nationwide discourse on workplace sexual harassment and threw wide open an issue which was swept under the carpet for the longest time. Even when people knew that these incidents are taking place, nobody spoke about it, nobody addressed it as such, and that is why this particular case has taken the initiative of bringing into force a particular law on a very important subject matter. In framing the Vishaka guidelines, like I told you, Supreme Court itself has given the guidelines that is going to be called as the law for this particular scenario till a particular enactment is not passed by the parliament. So when the Supreme Court was framing these Vishaka guidelines, they have relied on a particular international convention, that is the Convention on Elimination of All Forms of Discrimination Against Women, adopted by the General Assembly of the United Nations in the year 1979, and India is signatory and has ratified the same convention. And we know when we as a country sign an international treaty, international convention, we become obliged, we become obligated to ensure that all the contents of that convention is implemented at the national level. So the Supreme Court, while framing the Vishaka guidelines, has kept this particular convention in its mind, the provisions which are provided in this particular convention of the United Nations, and then it has drafted the Vishaka guidelines. Now, the Vishaka guidelines were issued under Article 32, that is nothing but the public interest litigation that was filed by various journalists and women, and it would have effect of law. Like I told you, the Supreme Court clearly said that Parliament has to make a law, but till the law is not brought into force, it is the guidelines itself which is going to have the effect of law. So the guidelines itself is going to be considered as the law, and it is mandatory for every employer, every organization, whether you are in the private sector or the government sector, to follow and abide by the provisions provided under the Vishaka guidelines. Same, in the absence of a specific law in India, the Supreme Court in the Vishaka judgment made it mandatory for every employer to provide mechanism for addressing the grievance pertaining to workplace sexual harassment. So after these guidelines were brought into force, every employer in the country had to make sure that they have a set mechanism, they have a protocol about dealing with such issues, how we are going to redress the issues, how we are going to provide a solution to the woman against such kind of wrongful activities taking place against them at workplace. So this was the first law for providing protection to women against workplace sexual harassment at workplace. The first law is the Vishaka guidelines. What is the impact of Vishaka guidelines? One particular case is given, Apparel Export Promotion Council versus A.K. Chopra. The Supreme Court reiterated the law that laid down in the Vishaka judgment. They said that whatever we have given the guidelines in the Vishaka case, the same thing has to be applied in this particular scenario. It upheld the dismissal of a superior officer of a Delhi-based Apparel Export Promotion Council who was found guilty of sexually harassing a subordinate female at workplace. And the Supreme Court clearly enlarged the definition of sexual harassment by ruling out that physical contact was not essential for amounting to act of a sexual harassment. In this particular case, what is the decision of this particular case? They have widened the ambit of the word sexual harassment. So earlier when you say sexual harassment, they meant that there should be a physical contact between the man and the woman. But after this particular case, they've said that there need not necessarily be a physical contact or a touch between a man and a woman. Even the mere words, verbal communication, actions, okay, all this can also be treated as sexual harassment. And this particular case led to widening of the ambit of the definition of sexual harassment, where the Supreme Court clearly has said that you should not look at the scenario as such. You should try to bring into the law into force in letter and spirit. What is our intention? Our intention by the virtue of these guidelines is to provide protection of women at workplace. That protection should be from all sides, from all aspects, right? And that is why they said that don't look into the mere letter that has been provided. You have to look into the spirit. What is the intention behind with which we have passed this particular law? And that is why the definition of the word sexual harassment has been given a wider ambit, saying that mere physical relationship or physical contact is not necessary to cause an act of sexual harassment. Mere words, verbal communication, actions, visuals, all this is also going to amount to sexual harassment. So this particular case led to widening of the definition of sexual harassment. The Supreme Court explained the same thing that I've told you. It is not necessary that there should be a physical relationship. Any verbal communication which is either direct or through an implication, through which even creating a wrongful working environment, a hostile working environment, an intimidating working environment where woman is not comfortable. There need not be a physical touch. Even by the presence of one particular person, if a woman is feeling uncomfortable, that means there is some kind of sexual harassment against her that is taking place. So not necessary that an actual act has to take place, but even if a scenario scenario or a situation is created at a workplace where a woman is feeling uncomfortable, that means there is some kind of wrongful activity under this particular enactment. Now, we'll look at the roadmap of how this particular act came into existence. So, after in 1992, when the particular case was filed and final judgment came and the Vishaka guidelines came, then the Vishaka guidelines, they have clearly said that the parliament has to pass a specific law. Till the parliament does not pass a specific law, Vishaka guidelines itself is the law. So, the parliament took the first step in 2007 to put before the Protection of Women Against Sexual Harassment at Workplace Bill of 2007. So, they laid the first draft of the law before the parliament in the house in the year 2007, but that law, this particular bill, was never discussed, and that is why it expired and it lapsed. Again in the year 2010, they re-brought that particular topic for discussion and placed it before the house or the parliament for discussion. And when it was introduced before the parliament, they referred that entire topic to a standing committee for having a brief discussion, research, what should be included, what should not be included, how we are going to draft about the particular law. They referred that entire topic for a standing committee, which was led by Shri Oscar Fernandez. This particular committee was given the work in the year 2010, and they submitted their report in December 2011. The standing committee, which was established for dealing with that particular subject matter, that submitted its report in the year 2011. Let us see what was the content of the report. First and foremost is, they changed the title of the bill. Okay, earlier it was only called as the Protection of Women Against Sexual Harassment at Workplace Bill of 2010. That was the name of the enactment which was originally proposed. Originally, the act was called as the Protection of Women at Workplace Against Sexual Harassment at Workplace Bill of 2010. But the standing committee said that we have to change the name of the act and we should call it as what it is addressed as today, that is the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act of 2013. So, they proposed it as a bill of 2013. The change of the title clearly reflected that the objective of the entire act should not be primarily on preventing such wrongful activities. If such we are making 100% efforts that such wrongful activities are not taking place. But if they take place, what is the solution? How we are going to deal about it? So, we are not only going to focus on prevention, but we should also focus on two other aspects, that is prohibition and redressal. So, from one objective, the ministry or the standing committee is recommended that we will not focus on one aspect. We are going to focus on three aspects: prevention, prohibition and redressal. So, this was one comment that was given by the committee, that we should change the title of the enactment and rename this particular thing. And that is why it was accepted, and the act as such we know is called as per the new name. Now, once it submitted the report, everything was accepted. Ultimately, in the year 2013, the act was brought into force. But between this scenario, when the bill was introduced, or between the Vishaka guidelines and the 2013 years, what was the situation? We know that the Supreme Court had given us the guidelines of what should be the scenario, how you are going to deal about the cases. But the guidelines which were given by the Supreme Court, which became the law for a certain duration of time, was not being implemented by various employers. It was not being brought into force, and that is why the Supreme Court had to again step up and issue a clear-cut notification that every employer has to comply with the Vishaka guidelines till the actual specific law is not brought into force. So, various petitions was filed before the Supreme Court again, okay, even after various bills were passed, laid before 2007, 2010, multiple times, though the bills have been placed, it was not passed as such. So, at that point in time, this particular person, Medha Kotwal Lela, coordinator, filed a public interest litigation, again highlighting that a lot of cases are taking place with respect to sexual harassment of women at workplace. And if you see these cases, the Vishaka guidelines are not being implemented at all by the employer. Though the Supreme Court has issued the guidelines, the employers are not following those guidelines, and that is when Supreme Court again stepped up and specifically provided that you have to comply with these guidelines. And then in the year 2013, we know that the act itself was passed, and it is based on the international convention that has been specified as such. So the foundation was the Vishaka case, because of which a public interest litigation was filed, through which the Vishaka guidelines were issued by the Supreme Court, and the Supreme Court has also directed the Parliament to make a specific law. Till the law is not brought into force, the Vishaka guidelines itself is going to have the effect of law, and once the act comes into force, the Vishaka guidelines are going to be put to rest, means they are not going to have in force because a specific law has been brought into force. So as soon as the PoSH Act has come into force, this particular act has replaced the Vishaka guidelines. Vishaka guidelines were in force only till a specific law is not being brought into force. So now this is the second law, and the second law is going to be prevalent, and this is what we are going to study in today's session. Now, talking about the basics, so when any law is passed, you should see that it is constitutionally valid. Any law should be in compliance with the constitutional provisions of the country. So if you see this particular concept of sexual harassment, in Indian Constitution also we have specific articles which talk that sexual harassment is wrongful, right? So sexual harassment results in violation of the fundamental rights of women, that is under Article 14 and 15 against right to equality, under Article 21 right to life and to life to live with dignity. If you are a woman is sexually harassed at workplace, her right to equality, her right to live a life with dignity, all these rights are violated, and violation of fundamental right itself is questionable. And these are the provisions which provide protection to women against sexual harassment under Indian Constitution. Coming to the actual enactment, that is the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act of 2013. In short, we are going to call it as the PoSH Act, Prevention of Sexual Harassment at Workplace. So it is the Indian law which is designed to provide protection to women at workplace against sexual harassment. It was brought into force on 9th December 2013. It has replaced the Vishaka guidelines as introduced by the Supreme Court, and it is the first comprehensive law of the country talking about a safer working environment for women in our country. Coming to the objective of the act, like I told you earlier, we only spoke about prevention. But once the committee, the standing committee recommended the change of the name and change of the objective, we are going to talk about three aspects. One is prevention, next is protection, and last one is redressal. Protection is also prohibiting the wrongful activities. So we want to prevent any kind of sexual harassment against women at workplace. We want to provide protection to women against any kind of sexual harassment at workplace, and we want to provide a complaint mechanism, how to file a complaint, how we are going to deal about that particular scenario, how a woman is going to bring that incident into limelight. So we are going to provide a redressal mechanism, how a complaint can be filed. All those aspects should be provided in the enactment itself. So the act is for providing prevention and prohibition of sexual harassment, for protecting the woman at workplace, and for redressing such issues as to how a complaint should be filed and how the matter should be heard and what are the final outcomes of that particular scenario in that particular given case. So this is the objective of PoSH Act. We are going to focus on three aspects: prevention, prohibition, protection, and redressal of the issue. Next, the purpose of the PoSH Act, again we know it is overlapping, protecting the woman against the acts of sexual harassment at a workplace, and also providing a redressal mechanism, complaint redressing mechanism. protecting the fundamental rights of women. Like I told you, we already studied in the previous slide that if a woman is subjected to sexual harassment at workplace, her fundamental rights of equality and right to live her life with dignity are being violated. So we should ensure that the acts of sexual harassment is also violating the fundamental rights of a woman, and that is not acceptable in any terms. Next one is to provide safe working environment to ensure that the women have a right to practice any profession, occupation. Merely because the environment is not safe, women cannot sit at home. Ensuring that I am subjected to such wrongful activities at workplace, it is better I stay away, it's better I don't work, it's better I don't take up this opportunity. Such thought should not come in the mind of the woman, and to ensure that the woman confidently can go to the workplace, we should ensure that we are going to provide them a safe working environment, and that is one of the objectives of this particular act. Lastly is to comply with the international obligations. Like we saw in the previous slides also, that India had ratified to the convention of all kinds of elimination of all kinds of violation against women. It is the United Nations Convention, which India has signed and ratified as well. So once you sign an international convention, it becomes an obligation on the country at a national level to implement the provisions provided in those conventions. And since we were the signatory, it was our obligation to comply with the international convention, and that was one reason why we had to mandatorily bring into existence this particular act. So these are the 4 reasons because of which we ultimately passed the PoSH Act. Next. Coming to, okay, we are seeing that we should provide protection. We are talking about sexual harassment at workplace. So the first thing that we have to address is understanding what is sexual harassment. What is the meaning of sexual harassment? We also saw one case where they said that the ambit of the word sexual harassment should be as wide enough to cover all possible cases which are creating some kind of discomfort to the woman at workplace. Okay, so the definition is given by the Supreme Court itself in the Vishaka judgment. In the judgment itself, the Supreme Court has defined the term sexual harassment, and once the act has been passed under section 2 subsection N, even the act also has accepted the same definition that is given by the Supreme Court. So if you study this definition is provided by the Supreme Court under the Vishaka judgment, which is also accepted under the PoSH Act. Let's see what is the definition. Sexual harassment includes any unwelcome sexually determined behavior, whether directly or implied or through implication. It is not necessary that there should be a direct effort from the side of the respondent or a man who is trying to make a woman comfortable. Any action, okay, indirectly trying to communicate something to woman, even that is going to be considered as a sexual harassment. There need not be a direct communication between the man and a woman where he is asking the woman for some kind of sexual favors. That is not necessary. Even mere implication by the conduct of a man can also be considered as sexual harassment. So it includes any physical contact or advances made by the man, a demand or request for sexual favors, sexually colored remarks, that is verbally or commenting on a woman, showing pornography or any other unwelcome physical, verbal, non-verbal conduct of a sexual nature. So whether it is physical, whether it is by a communication, or non-verbal means merely by some kind of actions or some kind of gestures, that can also amount to sexual harassment. So merely having a physical touch will lead to sexual harassment is the general mindset of the people, but the Supreme Court is very clear, and even the law that they've defined is very clear, where they want to follow the law in letter and spirit. Ultimately, what is our intention? To provide protection to women at workplace, to ensure that they have safe working environment. So it should not be having a restricted meaning. We should not have a restricted meaning to the word sexual harassment. We should keep the definition wide open to include all sorts of cases, all kinds of incidents which is causing some kind of discomfort to women, and that is why the definition itself has been kept wide open. Now, the incidents might lead to the causing of humiliation of the woman at workplace. It may constitute a health problem to her because of so much stress, anxiety, and it might also constitute a safety problem with respect to her. All of this also amounts to sexual harassment at workplace. So any scenario, any situation which is causing any kind of humiliation, leading to health problem of a woman, ensuring that she does not have safety at her office place, all this is also going to amount to sexual harassment at workplace. So sexual harassment is discriminatory in nature, because then the woman comes in a dilemma. Suppose there is a direct implication, a man has directly asked a woman for a sexual favor and says that if you don't do this, I am not going to give you a job. If you don't do this particular, I am going to stop your promotion. If you don't do this particular thing, I will ensure that you are removed from the office, you are removed from the work. So in that particular scenario, the woman is a dilemma, specifically if she is under some kind of obligation. Suppose she is in desperate need of that particular job for various reasons. What will she do in that given scenario? Should she accept the offer which is being given by the man? Should she raise her voice against it? Whether she is going to accept it, she is going to do it against her will, against her wish. Nobody wants to do it. So that is also not a situation to be in. Suppose she is going to reject it. What are the consequences of rejection? She might not accept the offer that is being given by the man. In that case, when she is going against the man who is asking for any kind of sexual favor, or who is going to try to cause a sexual harassment on a woman, when she is going to raise a voice against it, that is also going to have adverse consequences. So in that particular given scenario, any situation, whether you accept the offer, you don't accept the offer, it is going to be discriminatory for the woman who is in that particular situation. There might be adverse consequences if the particular woman does not consent to the conduct that is being questioned or raises any kind of objections. The woman say that no, I'm not interested, I'm not going to listen to you, you do whatever you want to do, I'm not going to give up to your demands, I'm not going to accept what you're going to say. In that particular scenario, the man will make all possible efforts to create a very stressful and a bad working atmosphere for that woman, so the woman finally gives up on the thing. Either she is going to accept it or she is going to quit the job and go. So in any case, the woman is at the loss. Whether she is accepting the offer, whether she is not accepting the offer, it is the woman who is going to suffer in that particular given scenario. And that is why we say that sexual harassment is discriminatory, whether it takes place or it does not take place. Ultimately, the woman is the person who is going to suffer in this particular given scenario. Now, the definition of sexual harassment is very wide enough to constitute both. Like I told you, directly if somebody is coming and telling you this is what has to be done, there is a direct conversation between a man and a woman, that can be a sexual harassment. But they have also said that implied sexual conduct, that means mere there is no as such communication between the man and woman. Through your conduct, through your gestures, indirectly you are asking a particular woman to grant something to you in the form of sexual favors. That is also going to be considered as sexual harassment. So direct, as it is, the wordings need not be there. If you are indirectly trying to imply a given scenario, even that is going to be considered as a sexual harassment. So whether it is physical, verbal or even written conduct, it is going to constitute sexual harassment. The most important thing that we have to keep into our mind, that the conduct should be unwanted. It should be unwelcome by the recipient. If a woman is very happy by that kind of offer which is being made by a man, she is willing to do it, okay, she is actually consented to do it, then there is no sexual harassment. She willfully has accepted to do it, she is willfully agreed to what the man has said. In that particular case, there is no sexual harassment. There should be unwanted and unwelcome incident for that particular woman. Today the woman is happy by the offer, she is accepted, she is done whatever the man has asked her to do. Ultimately, lately, she cannot file a case of sexual harassment against the man, because she herself had given the consent for that wrongful activity. Okay, so that will not amount to sexual harassment. So for categorizing as sexual harassment, it is very important that it should be unwanted and it should be unwelcome. The woman should not be happy in that given scenario or in that particular given circumstances that are in existence. Next. The scope of definition of sexual harassment we are discussing, it also includes intimidating, offensive and hostile work environment. Like I told you, it need not always be necessary that there should be a physical conduct or there should be a physical contact or there should be some kind of communication between a man and a woman. No, even if you are going to create an atmosphere which is uncomfortable for the woman, it is going to amount to a sexual harassment. They've given one scenario where an individual is subject to unwelcome comments about her body type, resulting in the woman feeling embarrassed, is unable to work properly. Going forth, somebody is passing by you and passing comments about you, about your body or anything which is making you feel embarrassed or uncomfortable at workplace, even that is also going to constitute sexual harassment. So the definition of the word sexual harassment is wide enough to include all sorts of cases which lead to some kind of humiliation, embarrassment, uncomfortable atmosphere for women at workplace. Next. What is considered as sexual harassment? Under section 3, they've clearly given certain list of activities which might lead to sexual harassment. First one is explicit promise of a preferential treatment in the victim's employment. What does this mean? It means to say that the woman is being appointed, or let's take a scenario, she's a fresher, she's come to give an interview. The man is conducting the interview, he says that if you give me so and so activity, if you grant me sexual favors, I am going to treat you, I am going to give you preferential treatment, I am definitely going to give you a job with a higher package when compared to other candidates who are applying. If you grant me sexual favors, I am going to give you a preferential treatment. I am going to ensure that you get this job and you get this job at a higher package. That is promising some kind of preferential treatment to the woman, to the victim, means the woman who is being addressed to such kinds of sexual harassment. So promising such things is also amounting to sexual harassment. In a given scenario, it can also take place that the woman is already employed in the organization and she is applying for promotion. In that particular case, the man can also say that we are going to grant you promotion if you grant me some kind of sexual favors. So that is giving some kind of preferential treatment over other candidates. In some kind of work scenario, that particular woman will be given preference if she is going to fulfill the demands of that particular man. Second one is implied or explicit threat of detrimental treatment. Here we are going to give preferential treatment. We are telling good things. We are going to give you promotion. We are going to give you a job. We are going to give you a higher package. All that is in positive aspect. Second one is a negative aspect, saying that if you don't do this particular thing for me, that is as demanded by me. The man says, if you don't do this for me, I am going to ensure that you don't get a job. I will ensure that you're removed from the work. I am going to ensure that in future also you're not going to get any job. So like that, you're going to threat them in a negative way. Next, implied or explicit threat about victims' present or future employment status. Same thing. If you don't do this for me, I will ensure that I give a negative remark while you're leaving the organization, so that the other organizations who are going to future employ you, they're not going to accept your application or your resume itself because of the remark that is being given by the previous organization. So that kind of blackmail or threat is also going to be considered as a sexual harassment. Interfere with the victim's work. The woman is trying to submit her work, is trying to dedicatedly work, but you're going to cause some kind of hindrance. You're not allowing her to execute her work to her utmost ability. You are the boss, the woman employees in your particular team. She is trying to put forth some point, you're not listening to her, you're not listening to what she wants to say, you're not taking her points into consideration, you're not giving her any kind of work, you're not giving her an opportunity to show her performance, to show her abilities. All this is hampering or interfering with the work of a woman merely because she is not accepted to your demands or is not fulfilling the request that is placed before by a man. And humiliating treatment given to a woman because which it is going to impact her health and safety. So in any way causing any atmosphere which is uncomfortable to a woman is going to amount to sexual harassment. So by including these points in the list of what amounts to sexual harassment, the definition of the word sexual harassment has widened itself. So this amounts to sexual harassment. Next. What is considered as sexual harassment? Again, in one particular case, Albert David Limited versus Anuradha Chowdhury and others. What happened in this particular case? A mere statement was made. The plaintiff, that is the woman, requested a man to instruct the attendants to switch off the AC because it was very cold. What happened? The woman directed one of the man, just requested that please can you tell the attendant to switch off the AC because it is extremely cold. In response to that, the man did not tell the attendee to switch off the AC, but he passed a comment on a woman saying that come close to me, you will start feeling hot. So merely a statement was made. It was a verbal communication between a man and a woman, but in this particular case, it was held that this particular comment that is made will amount to sexual harassment. This one case where you can clearly tell the definition of sexual harassment has a very wide meaning. This is a justification for that particular statement. Next. What are the forms of sexual harassment? On the basis of the points that we saw under section 3, we can classify on two bases. One is the actual quid pro quo, where actually something is happening, where something is being demanded, whether implied or explicit, that is preferential treatment or detrimental treatment, or you're going to give her a threat about her present or employment status. So here some kind of communication is there, whether implied or explicit as such. In this particular case, there is no act as such, there is no demand as such, but you are only creating the work atmosphere uncomfortable. You are going to ensure that the woman is not happy at her workplace. You're creating a hostile, intimidate, offensive work environment for the woman, which is going to indirectly help affect or impact her health and safety. So this is direct and implied or explicit, where some kind of demand is there, whether it is preferential, negative demand or detrimental demand, or some kind of threat with respect to future job opportunities. Here is you're not promising anything as such, but you're just making the atmosphere very bad for a woman to work. In that case, it is going to impact her health and her safety. That is why that is also going to amount to sexual harassment. Next. Applicability of the PoSH Act. So we have seen what is sexual harassment. Let's see the applicable provisions. The Act itself is applied both to the organized sector and to the unorganized sector. Organized sector is nothing but these corporates, etc., where more than 10 employees are there. Unorganized sector, in which what is going to be considered? Self-employed people and any organization in which less than 10 employees are there. It is going to be considered as an unorganized sector. Why is this distinction? Because under the law it is mandated that if any organization or any office has 10 or more workmen, it mandatorily has to constitute a ICC, Internal Complaints Committee, to deal with such scenario. So that is going to be considered as an organized sector where more than 10 employees are there. But if some person is self-employed, that is, I have my own office, I am self-employed, okay, and somebody is coming to meet me in my office and I am subjected to some kind of sexual harassment, whom will I complain to? Because there is no internal complaints committee. I myself am the owner, I myself am running this particular office, but I am subjected to sexual harassment. In that case, whom will I complain to? In that case, I will come under the unorganized sector. So they want to make the act applicable in such a way that every woman who is working is protected under the act. It is not necessary that she should be in a corporate, in a big office to be getting the benefits of this particular enactment. No. Any woman employee, whether she is working in a corporate or any scenario, any given situation, she should be able to seek protection under this particular act. And that is why we have said that the act is also applicable to the unorganized sector, where if you're self-employed and you're subject to sexual harassment by your clients or anybody who's coming from outside, you can apply for protection under the unorganized sector. And any organization in which less than 10 employees are there, even they are going to come under the unorganized sector. So the act is applicable to every kind of workplace where a woman is going to work. Next, applicability of the act. It is applicable to government bodies, non-governmental organizations, public and private sector organizations, any organization which is carrying on vocational, educational, entertainment, industrial, financial activities, hospital and nursing homes, educational institutions, a dwelling place or a house, sports institutions, stadiums, etc. So they have kept it wide open to cover each and every aspect that a place where a woman can be employed as a workman or as a employee. Next, who is an aggrieved woman? Some definitions we have to see to understand the provisions of the act. Aggrieved woman means, in relation to a workplace, a woman of any age. So we are not going to take the age into consideration. If you are an employee in a particular place, if you are employed as a worker in some kind of place, irrespective of your place and whether you are employed or not, that is also important. You are going to some workplace in professional capacity. You are not an employee of that organization, but you are visiting that particular office for something. You are going there to give interview. You are going there to meet one of the officers as a client, okay, whatever may be the given scenario. If you are going to visit that particular place, particular workplace, and alleges to have been subjected to a sexual harassment by the respondent man, then she is an aggrieved woman. In relation to a dwelling house, means a place where a woman might come to do the cleaning activities, to wash the dishes, to wash the clothes, to take care of the babies, the nannies, the gardener, the cook. All these are women who are going to come to workplace, that is your house, to give some kind of service. They are also going to be protected. A woman of any age who is employed in such dwelling house or in such particular dwelling place. So if any woman comes to your house for cleaning, okay, for taking care of your babies or for gardening work, for cooking, even those women are protected under this particular enactment. So when this point is very important, that a woman need not necessarily be an employee of the organization to seek the protection. A woman who is stepping into your office as a client or as a prospective employee, as a candidate for an interview, even she is going to be protected with respect to this particular enactment. Next, domestic worker. So like I told you, dwelling house, people who are going to work in a dwelling house. In a house, if somebody is going to work, that woman is also protected, and that is called as a domestic worker. Domestic worker means any woman who is employed to do a household work in any household. Remuneration, whether it is cash or kind. Cash means you are going to give her salary at the end of every month for the work that she has given, whether she has washed your clothes or whether she has cleaned your house, whether she has taken care of your baby, whatever may be the situation. If you are giving her some kind of money for the service that she is rendered, remuneration. Kind is, she says that I don't want money, just give me meals 2-3 times a day, give me the food, that is sufficient. That is in kind. You're giving her some kind of either cooked food or you're giving her the grains to cook for herself. You're giving her the grocery as such so that she can cook her food for herself. So whether you're giving cash or you're giving kind, doesn't matter. If she is coming to your place and you are giving her some kind of money or some kind of thing or material as such, either directly or through an agency who you are directly employed, or through an agency, that is nothing but contract. Now various agencies are there who have a list of all the women who are looking for some kind of work. You can contact the agency and say that I want a woman or I want a maid for so and so activity. They are going to route the work through the agency. You will pay the money to the agency will pay that woman, and the woman is going to be appointed by the agency, and the agency is going to tell that woman to which house you should go, what kind of work you should go, and what is the salary that you are going to receive. The agency is going to retain some percentage of the salary, and certain percentage of money they are going to give back to the woman for the work that she is going to do. In case that one woman is absent for some day, the agency itself is going to send a replacement for the number of days that particular woman is absent for. That is through agency. So whether you directly know the woman and you have appointed her, or you have appointed her through an agency, that is not the subject matter. If you have appointed her and you are giving her some kind of remuneration, cash or kind, she is going to be considered as a domestic worker and is protected under the PoSH enactment. Nature of work is also irrelevant, whether it is on a temporary basis, whether it is on a permanent basis, whether it is a part-time basis or full-time basis. We are not considered with that. If she is stepping into your house to do some kind of work, even for once, she is going to be considered as a domestic worker. And very important, it does not include a member of a family of the employer. So then in that case, there is no employer-employee relationship as such. So if a family member is doing some kind of work in the house, that person is not going to be called as a domestic worker. So this is the definition of domestic worker, where any woman is going to come to your house to do some work for remuneration in cash or in kind, and that she can be directed, either directly appointed directly by you or through an agency, or the nature of work can be permanent, temporary, on part-time basis, full-time basis, but it does not include a family member. So this is the definition of a domestic worker who is also protected under the PoSH Act. Next, definition of employee. Okay, employee means what is the nature of work? Any person who is employed at a workplace, whether on a regular basis, temporary basis, ad hoc basis or daily wage basis. We are not considered with that. Any one of these might be the nature of work, but you are considered as an employee of the organization. Again, mode of employment, either directly or through some kind of contractor or agency. Includes, like I told you, contractor with or without the knowledge of the employer. Remuneration, again, whether you're working for a remuneration, you're voluntary working without any remuneration. You say that you don't want, you're only going to give social work service, or you're going to work for your experience. You don't want any kind of money. So even if you're working voluntarily for no consideration, even then you're going to be considered as an employee. And designation can be anything. Okay, but if you are contributing some kind of work to the employer, you are going to be called as an employee. Employer, because there are a lot of obligation cast upon the employer for providing protection to women at workplace. So you should actually identify who is the employer of your workplace. So if it is any department, organization, undertaking, establishment, enterprise, office, branch, unit, etc., the head of that particular department, head of that particular organization, or any officer who is going to be appointed by the government. If it is a government sector, the government itself is going to identify one particular person as a head of the organization or head of a particular department. That particular officer is going to be considered as an employer for the purpose of complying with the obligations cast upon them under this particular enactment. Any workplace which is not covered under one means you do not have an organization, separate department as such, you don't have those designations as such. Any person who is going to be responsible for supervision and control of the workplace, that person itself is going to be deemed to be the head of the organization. Then the person who has the responsibility of supervision, he is going to be considered as the employer of that particular workplace. In case falling under scenario 1 and 2, specifically, the head of the organization might not be in a situation to look at any number of things. So there is an option of delegation of power. So in that scenario, if the head of the organization has delegated his work, has delegated his obligations about any other officer, such person who is entrusted with discharging those obligations is going to be considered as the employer. Not in given scenario, every owner of the organization can look into all the matters. So they are going to say that I am appointing you for the purpose of ensuring that you comply with the provisions of all this particular enactment. So he's delegated his power or his responsibility to somebody else. So the person to whom we are going to delegate that work, he is going to be treated as the employer for ensuring that all the obligations under this particular act are complied with. And in case of a house, who is going to be the owner? Any person who is going to benefit out of the work or a service that is rendered, that particular person is going to be considered as the employer. This is the definition given for the word employer. Now, next is respondent. Who is the respondent? Whenever we file a case, okay, whenever we file a case, it is petitioner versus respondent. petitioner is the person who is filing the case. In this particular case, it's always a woman who is going to file a case because the entire act is for providing protection to women. So if a wrongful activity has taken place, it is the aggrieved woman who is going to file a case. Somebody who suffered a wrongful incident, she is going to file a case, so she is going to be the petitioner. And the respondent is the man against whom some kind of complaint of sexual harassment has been filed. So who is a respondent? Respondent means a person against whom a aggrieved woman has filed a complaint under section 9, that is nothing but for sexual harassment. Next, unorganized sector. Unorganized sector in relation, I have already explained two things. First one is where a person is self-employed. You are the owner of the organization, you are self-employed, and you yourself being the owner is subjected to sexual harassment. Whom are you going to file a complaint before? In that case, you are going to be considered in the unorganized sector, and for the unorganized sector, we have the LCC, Local Complaints Committee, before whom you can file a case. So anybody who is self-employed, who owns a own office, is going to come under the unorganized sector. In addition to that, any place where the number of employees are less than 10, that is going to be considered as an unorganized sector. Next is definition of workplace given under section 2O. We have already covered this in the previous slide, so I am going to skip it. But again, when we see the definition of workspace or workplace, the definition is very wide. So two definitions are important. One is what is sexual harassment. That has to be very wide enough to include all kind of possible acts to be brought into force. Next definition is with respect to workplace, because we are talking about sexual harassment at workplace. So next is what is workplace is what you should identify. They have given us a list of places which can be categorized at workplace, but again the definition is very wide to include such other places. Should it be restricted to the compound of your office, or can an act of sexual harassment take place even outside the office? When you are going out with somebody on team lunch, when you are going to a client place, when you are going to be going to some other office on work, in your professional capacity, you are stepping outside your office. For the office work, you are stepping outside the office. Such other place where you are going, even that should be classified as a workplace. So again, the definition for workplace should be very wide enough to include all possible scenarios to be included in that particular definition. So two definitions should be very wide enough interpreted. One is sexual harassment, second one is workplace. So talking about the scope of the definition workplace, even when you are transporting from one place to another place, or when you are meeting somebody for lunch in the canteen, or you are going to some kind of restaurant in the professional capacity as a team lunch, in your personal capacity, if you are going as friends, if you are going as colleagues, then that is different. That will not come under the ambit of sexual harassment at workplace. When you are directed to go a particular place in your professional capacity, then it is going to be considered as a workplace. Two employees have been appointed to go to a third office, to a client place, and conduct a meeting in their premises. So they have been directed by the boss that you two people, A and B, should go to some place. In that case, A and B are going to that office because they have a direction through the workplace. That is why they are going. Otherwise, they would not go itself, and no wrongful activity could have taken place. So when a particular person is stepping outside their office in the professional capacity, even that such other place will be considered as a workplace. Logical meaning should be given to the expression workplace, so that we are going to give impact to the guidelines in a wider sense, to actually implement what is the intention of the law rather than following the spirit is the words itself. Workplace cannot be given a very restricted meaning. That is what they have upheld in various cases. We cannot say that workplace is the compound of your office. Once you are stepping outside the office, you are no more working. You are not eligible to seek protection under this particular act. Such kind of statements we cannot make, because we should try to provide protection to women at workplace in all possible scenarios. So such restricted meaning should not be given, and we should give a very wide interpretation to the definition of workplace. So whether you're traveling, whether you're going on lunch, whether you're going to some other office, whether you're going to somebody's house in professional capacity, all that is going to be considered as workplace for seeking protection under this particular enactment. Next. Workplace should be given broader and wider meaning as per the guidelines, and said wherever application is needed even beyond the compound of the workplace. Okay, that is what. And over a period of time, the technology has grown so much. Video calls are taking place where the CEOs are generally in their own houses, and they call upon their personal secretaries, or they call upon the staff to their house for conducting the meetings. Such scenarios are taking place. Earlier, it was a typical style of working where everybody is coming to office and working. Over a period of time, the culture has changed. We adopted to the Western culture where the meetings are taking place in the house. Such changes have been brought into force. So in that particular scenario, even the house of a CEO, where the CEO is calling somebody to their workplace, whether it's the personal secretary or other staff members, that particular place, that particular house also is going to be considered as workplace. So there is just given a particular case, Saurabh Kumar Malik versus Controller and Auditor General of India. This particular case is also for seeing the scenario where wide interpretation should be given to the definition workplace. Next. Same thing, it is talking about the same thing. Like I told you, technology is evolved, so wider interpretation of workplace should be given. Yes. Next, talking about the scope of the word workplace, the High Court has observed that the proximity from the place of work, the control of the management over such place or residence where the work is taking place, and such residence has an extension to contiguous part of workplace. So these three factors are taken into place while deciding whether a particular place comes under the ambit of workplace or not. Next, coming to the actual enactment. Okay, till now we are only seeing the definitions. Now let's see the actual provisions, enabling provisions, how we are going to provide protection. So this entire chapter, this entire enactment has 8 chapters. First chapter is preliminary 1 to 3, which talks about basic objective, and the enabling provision section 3, that is you should prevent any kind of sexual harassment at workplace, that is applicable to both organized and unorganized sector. Chapter 2 talks about constitution of the committee to take or address the issues. In case of organized sector, we should constitute the internal complaints committee. In case of organized sector, we should constitute the local complaints committee. So chapter 2 is applicable only to the organized sector, and chapter 3 is applicable only to the unorganized sector. Chapter 2 will not be applicable to unorganized, chapter 3 will not be applicable to the organized. If in an organized sector an act of sexual harassment is taking place, we should file a complaint before the internal complaints committee. If any kind of sexual harassment at workplace is taking in the unorganized sector, they are going to require to file a complaint before the local complaints committee. Next is how to file the complaint, what is the procedure, whether it should be written, whether there is some kind of format. All that is common for both organized and unorganized sector. Then comes the procedure of inquiry into complaint, that is also common. The entire procedure itself is common, merely the person to whom we are going to file the complaint, that is different. In ICC, you are going to have an employer who is going to have the primary responsibilities. So you have the duties of the employer. In case of unorganized sector, you don't have an employer as such, and that is why the duty is cast upon a district officer who is being given the power of employer as such for the purpose of unorganized sector. So in ICC, you have the employer who is going to have the responsibility. In case of LCC, you have the district officer who is going to assume all the responsibilities for fulfilling the obligations under this particular enactment. And last one is miscellaneous provisions, which is applicable to both organized and unorganized sector. So total there are 8 chapters in this entire enactment, out of which chapter number 2 and chapter number 6 are only applicable to organized sector. Chapter number 3 and chapter number 7 are applicable only to the unorganized sector. All other chapters are common for both organized and unorganized sector. So this is a brief gist of the enactment itself. Now first let's go about section 3, which is the enabling provision, which lays the foundation for this particular act, which says that there should be prevention of sexual harassment. So the wordings of the act is, no woman shall be subjected to sexual harassment at workplace. Clear cut mandate. It is the responsibility of ensuring that no woman should be subjected to sexual harassment at workplace. That is the law. If you're going to do any activity amounting to sexual harassment, it is going to be a punishable offense. Now, what amounts to sexual harassment? We have already seen this particular list of giving preferential treatment, detrimental treatment, threatening about present or future employment, creating a bad working atmosphere, anything that is going to impact our health and safety, all this going to amount to sexual harassment. We have already dealt with this in detail. So section 3 is the enabling provision, which says that no sexual harassment should take place at workplace. It also gives the list of activities which may amount to sexual harassment. Next is the actual thing about how we are going to redress the situation. The law says that there should be no sexual harassment. In case by chance some kind of sexual harassment activity takes place at the workplace, what is the woman going to do? Where is she going to file the complaint? How is she going to file the complaint? How is she going to deal with that particular scenario? All those things are also being addressed. So if you are in the organized sector, that means you are in a company where 10 or more workmen are there, and it is a corporate form of organization or as such, where it is structured. In that case, every organization which falls under the organized sector should constitute a internal complaints committee. So every organization having 10 or more employees is mandatorily required to constitute an internal complaints committee. If the company is not creating an internal complaints committee, that means they are not complying with the provisions of PoSH Act, and that is also a punishable offense. And in case you are in the unorganized sector, what is the unorganized sector? In case you are self-employed or there are less than 10 employees in an organization, in that case you can file your complaints before the local complaints committee. So there is a requirement for constituting the local complaints committee, which is the responsibility of the government. Here the responsibility is upon the company which is creating that ICC. Here the responsibility is upon the government for all other people who in the unorganized sector, like the domestic workers, like the maids who are coming to work, like the laborers, okay. For all of them, they are going to be protected under unorganized sector. Ultimately, the entire motive of this particular enactment is we should protect every woman who is going to step outside her house for the work, for any work that she is going to do. She should be protected, whether in organized sector or unorganized sector. Every woman is required to be protected and should be in a position to claim protection under this particular enactment. That wide enough provisions have been provided under this particular act. Next is internal complaints committee. First, this is applicable for the organized sector. What does the law say? Section 4 says that every employer where 10 or more workmen are there, it is mandatory for them to constitute and establish an internal complaint committee at every office and every branch. So in every office, every branch, you should have a ICC that is going to be constituted. The role of internal complaints committee is to address and resolve the complaints related to sexual harassment. Now, every complaint of sexual harassment need not be genuine and true. There are situations where women are filing false cases against men of sexual harassment. So that is why when a complaint is filed, it is not necessary that the outcome is man should be punished. No, you should hear both the parties. You should call the woman, ask her what happened. You should call the man, you should ask him what happened in a given scenario. Only after hearing both the parties, taking the evidence into consideration, we are going to determine whether sexual harassment has taken place or sexual harassment has not taken place. Merely because a complaint is filed before the ICC, it does not mean that a sexual harassment has taken place. It is for the committee to decide whether a sexual harassment has taken place or not. So they are going to address the issue. They are going to determine whether an activity has taken place or not. If it has taken place, they are going to give a solution for that. They are going to resolve that kind of issue. While you're constituting the internal complaints committee, you are going to have three category of people. One is the presiding officer, who is going to be the chairperson of the committee. You're going to have the other members who are from within the organization, from within the company, and you're going to have external members who are not part of your company, who are not a part of your organization. Somebody from outside is going to come and be a part of that committee, so that there is no bias in making the decision whether sexual harassment has taken place or sexual harassment is not taking place. So who is going to be the presiding officer? Any woman, okay, or the presiding officer can only be a woman employee, and that too who is in a senior position. In case you do not have any woman in a senior position, any other employee who is a woman and is having kind of administrative role as such, even that woman can be appointed as the presiding officer. So who can be the presiding officer for internal complaints committee? It should be primarily, you should give a preference to a woman. It definitely has to be a woman, the woman who is in a senior level, senior positions. But if you don't have any woman at a senior position, then any other woman employee who is suitable for that position, you can make her the presiding officer. Coming to the other members from the organization, you should have not less than 2. So minimum number of members, internal members, should be 2. Qualification, they should be from among the employees of the organization and should have proper experience in the field of social work or legal knowledge. They should have some kind of legal knowledge. They are going to constitute a member. It can be male or it can be a female, need not be very specific. Coming to external members, 1 member is mandatory, and the qualification is it can be anybody from an NGO or any cause which is related for women, familiar with issues relating to sexual harassment. They are going to be external members. So for ICC, you should have presiding officer who is mandatorily required to be a woman. Members and external members can be anybody, but they should have sufficient experience in some kind of social service, legal knowledge, or experience in issues relating to women. Okay, this is the constitution for ICC. But the most important thing that you should remember is whatever is the total strength of the committee, half of them, minimum 50% of the total strength, should be women members. So if you have total 7 members on ICC, at least 4 members should be women. At least 50% of the constituted committee should be women members. Next, what is the tenure of office? 3 years. Okay, such are the date that may be specified. Fees for external members. For internal members, we don't give a fees as such. But if you are appointing an external member, somebody from outside the organization to come and look into your cases and attend the meetings of the committee, you should give them suitable remuneration for having that designation in your organization. Now, casual vacancy, any member of the internal complaints committee can be removed from office before the expiry of 3 years of their service if they are contravening the provisions of this particular enactment, if they are convicted for any kind of offence or some inquiries pending against them for any nature, they have been found guilty for disciplinary proceedings, has abused the position in certain capacity. Okay, in all these situations, we are going to remove them and appoint a new member for the committee. Next comes the local complaints committee at the district level. Like I told you, this is required for the unorganized sector. In the unorganized sector, we should create the local complaints committee, and the responsibility of creating this lies upon the government. For ICC, the responsibility lies upon the company itself to create an internal complaints committee. So here at the district level, the government is required to set up a local complaints committee for the purpose of investigating and addressing the complaints of sexual harassment from 3 categories of situations, that is nothing but the unorganized sector. First one, that is the unorganized sector, which is nothing but where the ICC is not constituted, that in any case where there are less than 10 members or 10 employees. And second scenario, when the complaint is against the employer himself, or in case of self-employed people. In that particular case also, the complaints of sexual harassment is going to be filed before the local complaints committee. Next, notification of appointment. Because it is the district officer who is going to take the responsibility, through a notification, the appropriate government should appoint either a district magistrate or additional district magistrate or a collector or a deputy collector as a district officer for ensuring that the obligations under this particular enactment are fulfilled. ICC, we saw that the employer has the responsibility. In LCC, the district officer has the responsibility. But who is the district officer? So it is the responsibility of the appropriate government, whether the state government or the central government. They are going to notify anybody who is holding these designations is eligible to be appointed as a district officer. So it is left to the choice of the government out of these people whom they are going to appoint as a district officer. Through a notification, they should say that so-and-so person holding so-and-so designation is going to be appointed as a district officer under the PoSH Act. Such notification should be issued by the appropriate government, and once that notification is given, the person whose name is mentioned as a district officer, he will have all the responsibilities cast upon under this particular act. Next. Every district should have one local complaints committee which is going to be established by the district officer. So the responsibility of constituting a LCC lies upon the district officer. The role is to handle the complaints of sexual harassment under his jurisdiction. So there are so many districts in one state. Every district is going to have a district officer. Every district officer should constitute one LCC in his own district. So like that, every district is going to have one LCC for its own cases. So whatever case falls in your district if some kind of sexual harassment case has been reported, you should deal that in your LCC. Appointment of a nodal officer, because this is primarily in the unorganized sector, in the rural areas, or for the people who do not know how these particular incidents should be reported, you are going to appoint a nodal officer, nothing but an officer for the point in contact, who is going to help the members to file the complaints. He is going to go to the place and ensure that he is going to receive the complaints and forward those complaints to the LCC within 7 days. Okay, so you should have one nodal officer in every few villages, or what do we say, rural areas, tribal areas, taluk or block, so that he takes the responsibility that in this particular area, if something goes wrong, I will receive the complaint and forward it to LCC, because they are not very knowledgeable. They don't know what to do in a given scenario. So you're going to have a nodal officer who is going to take care of the responsibility. So what is the format of LCC? There is the government who has the responsibility of appointing a district officer. Okay, this district officer has the responsibility of constituting the local complaints committee. Further, this district officer also has the power to appoint a nodal officer who should ensure that the complaints are filed before LCC. He is going to receive the complaints from the people in the necessary district or area. They are going to receive the complaints to the nodal officer. Nodal officer is going to then forward it to the LCC. So the government is going to appoint the district officer. District officer is going to appoint the nodal officer. District officer is also going to constitute the committee. And whenever any complaints are being received by the nodal officer, is going to forward it to the LCC, which is going to be dealt with by the district officer, or that is nothing but by the LCC, the members of the local complaints committee. What is the constitution of this particular committee? There is going to be one chairperson who should be a woman from social work. One other member should also be a woman who is residing in that particular area, and 2 other members who can be nominated by the NGOs, etc. One official member is nothing but from the Department of Child Development and Women Development. These people are going to constitute the local complaints committee. Again, tenure is 3 years. Termination, same grounds. If you are found guilty, you have misused your position, you have given an influential decision, you have contravened the provisions of this particular enactment. In all these cases, the members of the LCC can be terminated and new members are required to be appointed. With that, let's put an end to this particular session. In the next session, we are going to cover the other aspects about once a complaint is filed. What is the procedure for filing a complaint, whether oral complaint is required or written complaint is required. Once a complaint is received, how is it processed, and what is the final outcome, how the judgment is going to be given. All these aspects we are going to deal with in the next class. If you want to get a notification about the next class, please subscribe to the channel so that you time and again get the notification about the newer classes that are going to be posted on our channel. And we have an upcoming batch which is going to start from January 10th. If you're interested to join, you can get in touch with us at 973-973-3400. We are always here to give you conceptual clarity and ensuring that you are prepared for your exams. Till the next class, take care and be happy.